My name is Valerie Verdun. I am an attorney in the Labor and Employment Group at Updike, Kelly & Spelliscy. This is intended to be a broad overview of two aspects of the major changes to family and medical leave benefits available to Connecticut employees. It does not constitute legal advice. Please contact our firm at 860-548-2600 and ask to speak with me or Chris Brigham, the chair of our firm's group. We'd be happy to answer questions about your particular situation. Today I will be discussing two public acts impacting Connecticut employers and employees. First, the changes to the already existing Connecticut Family and Medical Leave Act, and second, the new Paid Family and Medical Leave Act. It is important to keep in mind that some employers may also be covered under the Federal Family and Medical Leave Act, but we will save that topic for another day. The first significant change to Connecticut FMLA is that it now applies to employers with one or more employees. Prior to January 1st, 2022, Connecticut FMLA only applied to employers with 75 or more employees. Connecticut FMLA still applies only to private employers and excludes municipalities, local and regional boards of education, and non-public elementary and secondary schools. Under Connecticut FMLA, employees who have worked for an employer for 3 months will be eligible for 12 weeks of job-protected leave every 12 months, with a few exceptions. Connecticut FMLA is unpaid but job-protected. Job protection means that an employee must return to the same or an equivalent job after their leave. An employee's benefits, such as their health insurance, must also be protected during that time. Separate and apart from Connecticut FMLA, there is a new Paid Family and Medical Leave Act, which I'll refer to as Connecticut Paid Leave. Like Connecticut FMLA, Connecticut Paid Leave applies to employers with one or more employees, and sole proprietors and self-employed individuals may also opt to participate in the program. Connecticut Paid Leave provides up to 12 weeks of income replacement to employees during family medical leave, but it is not job protected. There is also different eligibility requirements for Connecticut Paid Leave. In order to be entitled to Connecticut Paid Leave, an employee must have earned at least $2,325 in the highest earning quarter of the first 4 of the past 5 quarters and must be currently working or had been employed and working in Connecticut during the 12 weeks prior to their leave. The passage of this act also created the Connecticut Paid Leave Authority. All benefits under Connecticut Paid Leave are determined and paid out by the Connecticut Paid Leave Authority. It undertakes a specific calculation to determine the amount of benefits an employee is entitled to. Both statutes, Connecticut FMLA and Connecticut Paid Leave, are triggered by the same set of qualifying events. An employee may be entitled to leave for the birth of a child or the placement of a child with the employee through adoption or foster care. Leave can be taken to care for this child within the first year of its birth or after the child's placement. Leave can be taken for the employee's own serious health condition or to serve as an organ or bone marrow donor. Leave can also be taken for an employee to care for a family member who has a serious health condition. An employee may take leave to address qualifying exigencies arising from a spouse, son, daughter, or parent's active duty in the military, or to care for a spouse, son, daughter, parent, or next of kin who has a serious injury or illness incurred on active duty in the armed forces. Under both Connecticut FMLA and Connecticut Paid Leave, employers may require employees to use their paid time off concurrently during their leave. However, employees must be able to maintain up to 2 weeks of accrued PTO to use after they return. As a result of the Connecticut Paid Leave and the changes to Connecticut FMLA, there may be multiple laws that an employer needs to consider when an employee is on leave. In many cases, the benefits under these laws will run concurrently, but there also may be instances where one law applies but others do not. It is important for the employers to consult with the attorneys at Updike, Kelly & Spelliscy to ensure compliance with all of these laws. We have many additional resources available on our website, and our firm also sends out client alerts about important developments in the labor and employment realm. Please contact me or Chris Brigham, the chair of our group, at our email addresses that are posted on our website or at 860-548-2600. Thank you.